hosted by the Leadership Conference Education Fund. I'm Sandy Close, Director of Ethnic Media Services, which is honored to work with the Leadership Conference. On this briefing, the Leadership Conference has been a tremendous ally of ours dating back to the early 2000s when LCCR funded the first multilingual poll on ethnic media usage nationally and gave us our first office in Washington. So that's how long these ties go. Today's briefing focuses on education and civil rights, what to expect in the year ahead. Experts and advocates in the civil rights field will preview the education policy landscape, ranging from Supreme Court challenges to federal student loan debt cancellation and affirmative action, as well as early childhood care and education. Our speakers include our moderator, Liz King, Senior Program Director for Education Equity for the Leadership Conference Education Fund, Genevieve Genzi Bonadis Torres, Associate Director for Education Opportunities Project of the Lawyers Committee for Civil Rights under Law, Michelle N. Turnage Young, Senior Counsel for the Legal Defense Fund, LDF, A.J. Link, Policy Analyst for Autistic Self-Advocacy Network, or ASAN, Morgan Craven, J.D., National Director of Policy, Advocacy, and Community Engagement, Intercultural Development Research Association, known as IDRA, and Whitney Pessic, J.D., Director of Federal Child Care Policy for the National Women's Law Center. This is an incredibly impressive lineup, and we're grateful to all of you. We ask you to speak slowly for our interpreters in Spanish, Mandarin, and Korean. And we ask our colleagues to enter questions in the chat and our speakers to answer the ones they can in the chat. Since we have 6 speakers, we may only have a little time at the end of the presentations for a few questions. So back and forth on the chat will be very helpful. We will send a video of today's briefing and expanded bios with contact information for each speaker to all participants later today. And now I turn the microphone over to Liz King, who will moderate today's briefing. Thank you, Liz.
Thank you, Sandy, and thank you to everyone who has joined us today. My name is Liz King, and I am the Senior Program Director for Education Equity at the Leadership Conference Education Fund. The Leadership Conference Education Fund builds public will for laws and policies that promote and protect the civil and human rights of every person in the United States. The Education Fund was founded in 1969 as the education and research arm of the Leadership Conference on Civil and Human Rights, the nation's oldest and largest civil and human rights coalition of more than 230 national organizations. Today, we are going to talk about the education and civil rights landscape in 2023. The civil and human rights community works together every day to protect all students from discrimination and ensure equal opportunity in education. We know that education policy decisions must be informed by the values, priorities, and experiences of marginalized people. For too long, people of color, Native people, LGBTQ people, people with disabilities, immigrants, religious minorities, English learners, girls, low-income people, and other marginalized people have had their stories told by someone else. Their opportunity to attend a school that is warm, welcoming, and that prepares them for the full exercise of their social, political, and economic rights has been denied. We are here today to talk about threats to equal opportunity and the need to advance justice and equity. We will hear first about the significant harm Black and Latino students would face if the Supreme Court rejects the president's program to cancel student loan debt. Then we will hear about the need for the Supreme Court to uphold affirmative action policies that create the diverse campuses Americans believe in and which contribute to a multiracial democracy. Next, we will hear about the need for safe, healthy, and inclusive schools that reject discriminatory and criminalizing practices. We will also hear about the attacks on teaching about race, the efforts to whitewash history and exclude LGBTQ children and families from their schools. Finally, we will hear about the need to ensure access to equitable, high-quality early care and education and protect the civil rights of our youngest learners. We hope that this will be the beginning of a conversation and look forward to staying in touch in the year ahead. Now I'll turn it over to Jenzy Bonadis-Torres with the Lawyers Committee for Civil Rights Under Law. Jenzy?
Thank you so much, Liz. The COVID-19 pandemic was an unprecedented health, social, and economic crisis. The Biden-Harris administration's student debt relief plan is an urgently needed moral and lawful response. The plan provides targeted relief for over 40 million working and middle-class Americans whose family finances and entire livelihoods were devastated by the pandemic. Without this relief, millions of borrowers would be pushed past the financial brink when student loan repayments restart. And among them are millions of borrowers of color who we know have been hardest hit by the pandemic. This foreseeable spike in default would debilitate the credit of millions of borrowers, blocking their ability to pay for basic necessities and preventing them from securing affordable housing, among other adverse outcomes. The Higher Education Relief Opportunities for Students Act, or HEROES Act, authorizes the Secretary of Education to mitigate precisely these harms. And yet, opponents with politicized and special interests have launched several lawsuits challenging the legality of this amply justified debt relief plan. Most of these lawsuits have been dismissed, but two have made their way to the Supreme Court: Biden versus Nebraska and the Department of Education versus Brown. The cases have been expedited with oral arguments scheduled for February 28th. Let me be clear. The debt relief plan faithfully adheres to the HEROES Act. Specifically, the HEROES Act allows the Secretary to take action in a national emergency, in this case COVID-19, to make sure affected borrowers are not placed in a worse place financially because of that emergency. Evidence shows that the debt relief plan achieves exactly these aims, and key civil rights are on the line. The Lawyers Committee spearheaded a friend of the court brief, or an amicus brief, along with 21 advocacy organizations that underscores how the stakes are especially high for people of color, and particularly women of color, because COVID-19 has exacerbated racial disparities and inflicted acute harms on Black and Latinx borrowers. To begin, Black and Latinx borrowers disproportionately shouldered economic setbacks from COVID-19. Unemployment rates spiked for all lower income workers, but women of color faced the greatest losses, with approximately 1 out of 5 Latina and Black women abruptly finding themselves without work. COVID-19 also took a disproportionate toll on the health of Black and Latinx communities, whose infection and death rates were substantially higher than average. Such losses further destabilize the ability of Black and Latinx families to meet basic needs, much less repay crippling student debt. Moreover, the financial obstacles arising out of COVID-19 are amplified for Black and Latinx borrowers because of pre-existing racial disparities in wealth and student debt. The volatile economic conditions created by COVID-19 forced many families to rely on existing wealth to serve as a safety net. But Black and Latinx borrowers have far fewer financial means to fall back on due to discrimination in the labor market and generations of government-sanctioned policies that prevented people of color from accumulating wealth. While the typical white family today enjoys about $184,000 in family wealth, a typical Black family has about $23,000 and a typical Latinx family has $38,000. Consequently, Black and Latinx students are forced to carry higher levels of student debt and simultaneously face even greater difficulty in paying off such debt due to the pandemic's aggravating effects. Biden's debt relief plan promises to prevent severe economic fallout from the pandemic. It provides relief to over 40 million lower-income Americans, and disaggregated by race, it's anticipated that approximately 50% of Latinx borrowers and 25% of Black borrowers will have their debt balances eliminated. Additionally, it's estimated that the first $10,000 of relief will move over 500,000 Black borrowers from a negative to a positive net worth. Altogether, the facts and the law support the Biden debt relief program, and the Supreme Court should uphold it. In addition to the debt relief cases, the educational and economic opportunities of students of color are under threat in the pending affirmative action cases against UNC and Harvard. Michelle will be covering these cases in further detail, but I did want to highlight our client's important role in these cases. The Lawyers Committee currently represents a multiracial group of former applicants, students, and alumni at UNC, as well as at Harvard and UT Austin, who are defending their university's right to consider race as one of many factors to promote diversity and equal access. Our clients put forth critical testimony at the trial level, which the district court heavily relied upon in upholding UNC's race-conscious policy. And more recently, the Supreme Court granted our clients oral argument time, and my colleague David Hinojosa presented on their behalf, lifting up the voices of UNC students and alumni of color who speak directly and powerfully to the importance of considering their racialized experiences to fully comprehend their accomplishments, the profound benefits of the racial diversity they encountered once on campus, and how interacting across racial difference better prepared them to excel in our global workforce. The Lawyers Committee stands in solidarity with the diverse group of stakeholders in both the affirmative action and the debt relief cases who are urging the Supreme Court to uphold the legality of the programs. Both are fully consistent with statutory and constitutional authority. They also strengthen our multiracial democracy by ensuring pathways to educational and economic opportunities remain open to students from all walks of life, including Black and Brown students who have been shut out for far too long. And I will look at the questions in the chat, and I will try to respond via the chat because of time, and I will try to pass it back to Liz now.
Thanks, Jenzy. Next, we'll hear from Michelle Turnage Young with the NAACP Legal Defense and Educational Fund, LDF. Michelle?
Thanks, Liz. Thanks, Jenzy. So my name is Michelle Turnage Young. I serve as Senior Counsel at the Legal Defense Fund. As background, the Legal Defense Fund is a nonpartisan organization that has fought for equal access to higher education for more than 80 years. LDF has been involved in every race-conscious admissions challenge to ever make it to the Supreme Court. And together with my colleagues, I represent 25 Harvard student and alumni organizations comprised of more than 16,000 Black, white, Latinx, Native, and Asian American students and alumni as amici curiae in the Harvard lawsuit. In both the Harvard case and the UNC case, the petitioner, SFFA, asked the court to change the law to ban the consideration of race in admissions. SFFA also alleges that both Harvard and UNC failed to comply with existing law. So let me briefly discuss existing law. Under 44 years of settled precedent, it is legally permissible for colleges and universities to consider race as one of many factors in admissions. Bear in mind that the Supreme Court held that quotas were impermissible back in 1978. So we're not talking about quotas. What we are talking about is the limited consideration of race as one of 40 factors in the UNC case and one of more than 100 factors in the Harvard case. UNC is the oldest public university in the country. As was the case with earlier challenges to the admissions policies of public universities, SFFA alleges that UNC violates the Equal Protection Clause of the 14th Amendment of the US Constitution by considering race as one of many factors in admissions. Importantly, the Equal Protection Clause of the 14th Amendment applies to state actors like public universities. It does not apply to private actors. The Harvard case is the first challenge to a race-conscious admissions policy involving a private college to reach the Supreme Court. But even though it is a private university, Harvard receives federal funding. So in the lawsuit, SFFA alleges that Harvard's consideration of race as one of many factors in admissions violates Title VI of the Civil Rights Act of 1964, which prohibits federally funded programs from engaging in racial discrimination. Unlike the UNC case, there's also an allegation in the Harvard case that Harvard engaged in intentional discrimination against Asian American applicants. That claim is novel since in earlier admissions challenges, the claim was that the consideration of race in admissions harmed white applicants. In both cases, the petitioner asked in their complaints that the schools be barred from allowing their admissions officers to become aware of the race of any applicant. All of the lower courts issued 100+ page rulings in favor of the schools. In the Harvard case, the court held that Harvard's admissions policy survived strict scrutiny because it was narrowly tailored to achieve the compelling interest in the pursuit of the educational benefits of diversity. In addition, while 8 student and alumni witnesses testified about the importance of diversity, not one witness testified that they had been discriminated against. And even though SFFA analyzed 480 admissions files, 2/3 of which were selected by SFFA, and data from about 150,000 applicants, SFFA did not present even a single admissions file or application that it contended reflected an applicant who would have been admitted absent discrimination. Given this, the court found no evidence of intentional discrimination. The U.S. Court of Appeals for the First Circuit affirmed that decision. In the UNC case, the district court likewise held a long bench trial, then held that UNC's admissions policy passed constitutional muster. The Supreme Court decided to hear the UNC case before the appellate court could weigh in. And of course, as I'm sure most of you know, the Supreme Court heard 5 hours of oral argument on Halloween in 2022. We heard from the oralist and the Solicitor General that it continues to be of the utmost importance to our multiracial democracy that the pathways to leadership in our country be visibly open to people from all corners of our society. A September 2022 nationwide poll found that 87% of respondents agreed that diverse learning environments enrich the college experience for everyone and better prepare students of all backgrounds for success in our increasingly global multiracial economy. All students deserve a fair shot at getting a quality education, regardless of their income, where they grew up, or their racial or ethnic backgrounds. But unfortunately, while talent is everywhere in our country, opportunity is not. Too many students of color must contend with systemic and interpersonal racism that detrimentally affects their educational opportunities. It is important that colleges and universities continue to be allowed to consider the full context of applicants' experiences, including the way that racism artificially depresses the prospects of many hardworking, talented Black, Latinx, Native, and underserved Asian American students so that everyone has a fair shot.
Thanks, Michelle. A reminder to our speakers to speak slowly. I know we feel passionate and enthusiastic about all of these issues. Next, we'll hear from AJ Link with the Autistic Self-Advocacy Network. AJ?
Thank you so much, Liz. My name is AJ Link. I am wearing a green hat with a yellow lightning bolt because I am from Tampa with a gray shirt. I am going to talk about threats to safe, healthy, and inclusive schools. And the first thing that I would like to do is present the 8 principles of a safe, healthy, and inclusive school climate provided by the Leadership Conference. Principle 1 is to ensure the rights of our students. Principle 2 is to encourage schools to implement comprehensive, supportive discipline practices. Principle 3 is to address childhood trauma. Principle 4 is to enhance protections against harassment and discriminations in schools. Principle 5 is to ensure accountability through accurate and comprehensive data collection. Principle 6 is to invest in school infrastructure that supports positive school climates. Principle 7 is to eliminate school-based law enforcement. And principle 8 is to eliminate threats to students' health and safety. So what can we do in this legislative environment? Well, there's a suite of bills that the Leadership Conference has endorsed and ASAN has signed on to those. And those are the Counseling Not Criminalization in School Act, which ends federal funding for school-based law enforcement and redirects those funds to counselors, teachers, and positive supports for children in schools. There's the Keep All Students Safe Act, which ends seclusion and places significant guardrails around the use of restraints in schools. There's the Protecting Our Students in Schools Act, which ends corporal punishment in schools. The Safe Schools Improvement Act, which establishes federal standards to protect every student from bullying and harassment in K-12 schools. And the Ending Pushout Act, which supports alternative to exclusionary discipline in schools and prevents criminalization and pushout of students from schools, and especially girl students of color. So these bills are in opposition to things like threat assessment, which are extremely dangerous. As a disabled advocate, we are very much against any type of school hardening bills, which puts the threat and safety of our students in danger. All students deserve safe, healthy, and inclusive school climates. Every student deserves the opportunity to attend positive school environments that support their rights, protect against harassment and discrimination, and ensure their health and safety. Thank you so much, Liz.
Thanks, AJ. Next, we'll hear from Morgan Craven with IDRA. Morgan?
Hi, everyone. Thank you so much, Liz. My name is Morgan Craven. I am the National Director of Policy, Advocacy, and Community Engagement at IDRA. We're a nonprofit focused on ensuring all students have access to excellent and equitable public schools that prepare them for college. I'm going to speak about the attacks on equal educational opportunity that we have seen in the form of classroom censorship, the targeting of systemically marginalized students and communities, and challenges to schools' diversity, equity, and inclusion efforts. At IDRA, we know from 50 years of education, policy, research, and teacher training work that culturally sustaining schools are key to students' success. And what we mean by that is this: culturally sustaining schools are places where every student feels welcome. No one is asked to check parts of their identity at the door. Everyone sees themselves and their communities reflected in the curriculum and instructional practices. Diversity, equity, and inclusion efforts are meaningful, and everyone feels safe. We know that these types of learning environments are beneficial for all students and adults in a school community, and we must challenge any efforts to undermine them. We believe that in 2023, we will continue to see policies that threaten the schools that we want for all students. We expect to see policies at the federal, state, and local levels that continue to curtail inclusive curriculum and instructional practices, target young people of color and LGBTQ+ youth, eliminate diversity, equity, and inclusion programs, and ban books and other materials in both K-12 schools and institutions of higher education. We expect federal hearings in the House that target individuals, schools, and organizations that promote diversity, equity, inclusion, and culturally sustaining initiatives in schools. And we expect to see more parental rights framing across a number of issues, and not the inclusive framing that we want, but a politicized and divisive approach to family engagement in schools. To give a bit of background on the policies that I'm describing, attacks on equal educational opportunity have certainly come in many forms over many generations. But a few years ago, we began to see a coordinated effort to attack what was framed as critical race theory, or CRT, in K-12 schools. It's important to know that the so-called anti-CRT movement has never really been directly about eliminating the academic legal framework known as critical race theory. Fundamentally, it has been about censorship and about control over our collective history and narratives, over how we talk about discrimination, bias, and even race itself, and control over how we are able to create the diverse, inclusive, and equitable schools that we want. According to an analysis by Education Week, since 2021, 42 states have proposed or passed policies that fall under the umbrella of classroom censorship. One thing that we've always known is that the attacks would be much broader than just those initial issues. Those who have pushed classroom censorship beginning in 2020 have also politicized other issues in schools. They have targeted and excluded LGBTQ+ students through restrictions on self-expression, participation in activities, and access to physical spaces in schools. They have challenged books and passed book bans in local districts that target the works by and about people of color and the LGBTQ+ community. And there have even been reports of local law enforcement confronting school librarians. They have promoted a warped view of parental rights that does not encourage diverse, meaningful, and authentic family engagement in schools, but rewards violent rhetoric and divisive action for political gain. They have proposed vouchers and other funding schemes that would take public funds away from public schools if families decide they don't like what's being taught. And they have threatened the academic freedom that is central to our institutions of higher education. Just yesterday, the Lieutenant Governor here in Texas, where I'm located, doubled down on previous threats to target professors at colleges and universities that teach CRT or other so-called liberal philosophies. And the consequences of these campaigns are not just rhetorical, they are real and they are very serious, and I will give you a few examples. We know that individual students report feeling targeted because of policies that promote racism, gender-based discrimination, and anti-LGBTQ+ beliefs in their schools. And this creates barriers to their learning. We know that students, teachers, and families feel excluded from and unwelcome in their school communities when curricula and books about people like them are condemned and challenged or banned. We know that key civil rights protections are being challenged in a number of ways, including through attempts to stop data collection about student outcomes based on race, and to eliminate research-based strategies that would address racial inequities in learning and achievement, even by framing those strategies as racist themselves. For example, the Virginia governor's first executive order attempted to do just that within the state education agency. We know that identity-based bullying and harassment continue to go unaddressed in schools, contributing to hostile learning environments. This was certainly a problem before classroom censorship laws and other attacks on identity, but students are reporting experiencing this type of targeting even more lately. And teachers and administrators say they feel confused about how they are expected to talk about and respond to discrimination when they are denied training or when they are issued a list of so-called divisive concepts that they're not allowed to address in their classrooms. And finally, our teachers or would-be teachers are reporting feeling direct fear and the chilling effects of these policies, which heightens an already problematic teacher shortage issue across the country. I'll end by reviewing what a lot of young people, families, and advocates are pushing for besides a repeal of these harmful policies. We're pushing for clarity and enforcement of protections for all students at all levels. Federal and state authorities have a responsibility to protect the rights of all students and to be clear when state actors, schools, and districts have discriminatory policies that threaten those rights and compromise learning. We are pushing for resources, training, and support for culturally sustaining schools. Administrators and teachers need support to teach truthfully and authentically, and to incorporate culturally sustaining practices into their classrooms. They should be able to explain a range of challenging and important concepts in an age-appropriate way without fear of attacks from their communities and without feeling like they are compromising their livelihoods. And finally, we want support for authentic school, family, community engagement and partnerships. Family leadership and community involvement are really important in schools, but that needs to be collaborative and inclusive and not combative. I'm going to drop some resources in the chat that we have found teachers, families, and students requesting, including a resource hub that we put together with lesson plans, materials, and other resources. And I'd be happy to answer any questions in the chat. I will keep an eye out for those, and I'll pass it back to you, Liz. Thank you.
Thanks, Morgan. Our last speaker will be Whitney Pessic with the National Women's Law Center. Whitney?
Thank you, Liz and Morgan, and I appreciate you all sticking with us. My name is Whitney Pessic, and I'm the Director of Federal Child Care Policy at the National Women's Law Center, and I'm a second-generation early educator, so this issue is very personal to me. At the Law Center, we are advocates, experts, and lawyers who fight for gender justice, taking on issues that are central to the lives of women and girls. We drive change in the courts, in public policy, and in our society, especially for women facing multiple forms of discrimination. We use the law in all its forms to change culture and drive solutions to the gender inequity that shapes our society, and to break down the barriers that harm all of us, especially women of color, LGBTQ+ people, and women and families with low incomes. We are entering year 4 of a pandemic that pressure tested an early care and education system already in crisis, causing devastating results across the country for early educators and families alike. For the early care and education sector, the COVID-19 pandemic has laid bare and exacerbated the deep inequities of an early care and education system that relies on families paying unaffordable sums, early educators being paid poverty-level wages, and too many communities across the country lacking sufficient workforce or facilities to meet early care and education demands. In more than half of states, care for an infant in an early care and education center costs more than in-state college tuition. And in one study, well over half of 2-child families spent more on childcare than on rent. Additionally, federal dollars don't come close to subsidizing all the children and families who are eligible for assistance paying for early care and education. Families, particularly in rural areas, struggle with a lack of care options. Research has found that over half of people in the United States live in an early care and education desert, or a neighborhood with an insufficient supply of licensed care. The problem will not fix itself. U.S. Treasury Secretary Janet Yellen summed up the dynamic well. Childcare is a textbook example of a broken market. The cost of childcare has been rising faster than inflation for years and will continue to rise steeply absent public investment. Over the past 30 years, early care and education prices have risen faster than twice the rate of inflation, faster than the price of food, housing, and other items. These rising prices squeeze families, crowd out other expenses, and push parents, especially mothers, out of the labor force. Not only is the lack of federal investment in early care and education impacting families, but it is also one of the lowest paid professions in the United States, despite how valuable the work is and the extensive research pointing to the importance of the early years for young children's healthy development. Wages for childcare providers average less than $12 per hour. About half of programs do not offer health benefits, and recent data shows that over half of early educators were enrolled in at least one public assistance or support program. The pandemic has only brought more challenges, especially for women of color who comprise a significant portion of the underpaid early care and education workforce and also have the least access to affordable care for their children. And it's not only the adults who are impacted. Children under 5 years old are the most diverse generation in United States history. So investing in high quality, affordable care and education also advances racial equity. It is a racial and gender justice imperative to address these deep inequities in the United States early care and education system. In order to ensure that children and families have access to and are included in comprehensive, diverse, and high quality early care and education settings, we seek policies that reflect our coalition's civil rights principles for early care and education, as well as robust federal investment to implement these policies. These principles were developed collaboratively by members of the Leadership Conference on Civil and Human Rights and by the Leadership Conference Education Fund. The coalition sought to identify fundamental elements of the whole early child care and education system that protect civil rights and advance equity for children, families, staff, and providers. In 2023, the Law Center and the coalition will continue to engage and educate diverse stakeholders and policymakers in pursuit of an early care and education system that offers meaningful, equal opportunity and success for all children, especially those historically marginalized, which includes robust federal investment to implement these policies. Thanks, and I'll hand it back for questions.
Thanks, Whitney, and thank you again to all of our speakers. Now we are going to take questions in the chat. I will flag, I saw there was a question from Seema that talked about the underrepresentation of South Asian Americans in the discussion about student loan debt cancellation. Jenzi mentioned that one of the problems we have here is a data problem. I know that there has been a lot of conversation around the census. We know that without data, communities become invisible. Unfortunately, we do not have enough data about Asian American student loan holders, and especially within that, the diversity of Asian Americans and the diversity of Asian American student experiences with respect to education and student loan debt. So we'll lift that, see if there's any additional follow-up question on that. Also, Vince, we saw your question that Michelle answered in the chat about the distinction between quotas and what is currently allowed under the legal system, to see if there's any follow-up questions around that. And then we'll encourage folks, if they have any other questions, to include them in the chat. And we'll also name that we will follow up with the principal documents that were referenced and which describe the consensus positions of the civil rights community as we're advocating for educational equity. So I'll just give it a minute to see if there's more questions in the chat.
Hi, there are questions. I think we're all digesting the legal consequences, and a very important question from Orhan or our court is, what happens if the debt cancellation does move forward? How will the entire system be affected? If debt relief is actually allowed to move forward, what positive changes do you see? And if it isn't, what's the worst thing we should expect?
So if debt relief is allowed to move forward, then over 40 million borrowers would be eligible for applying for relief. I have to pull the exact numbers on how many have already applied, but it's in the millions. It's might be 16 million. It might be above that by now. And as a reminder, those who qualify are those with individual incomes of $125,000 or less, or jointly of $250,000 or less. And then Pell Grant recipients, which is a means-based program. So those who are Pell Grant recipients are lower income would be eligible for an additional $10,000. As I highlighted in my remarks, for many borrowers who are the most in need of this relief, this can eliminate their debt entirely, which means that they can focus on paying the other basic needs in their life, food, housing, getting their kids through school. For other borrowers, it may not eliminate entirely their relief, but the department found that it would substantially reduce their monthly payments to an extent that would mitigate their likelihood of default and delinquency. And as I mentioned, default has really severe and serious consequences. By ruining somebody's credit, it makes them at risk for secure housing. It can imperil their employment. It means that it is very difficult for them to get basic necessities in their life. And the research that the department relied upon shows that after long payment pauses like this one, during national emergencies, there are spikes in default and delinquency. And this plan is specifically designed to avoid those types of spikes that are linked to the pandemic. By contrast, having less debt is linked with better outcomes, which perhaps is not surprising. Everything from being able to secure safe housing to better employment opportunities and more. So I will leave it there for now, but I do think that the economic security of so many Americans are on the line, and that it's particularly crucial for people of color because, again, they don't have the same safety net of wealth, and they do have substantial debt.
Thank you. Thank you. There's a question I have in the text, and I think it's very relevant for AJ Link, which is the principles that have been articulated, which we will be sending to everyone on this call, really relate to how individual school districts and even schools themselves are administering their student bodies. And we're looking at this from a national level. How can we, as ethnic media journalists, monitor what's going on in individual school districts where some of these principles are really being tested and violated, but parents may not have the support that they need or would have if we were able to publicize what was happening?
Yeah. Hey, y'all, this is AJ speaking, and Liz, feel free to jump in if I miss anything. But I think it's important that with the suite of bills that we're proposing for safe housing and effective school climates, it's getting funding at the federal level and investing in, it's investing in things that would make schools safer and better so that school districts have the funding in order to implement the types of things that we need. So that would include more counselors, right? That would include the infrastructure to have better support systems, and it would take funding away from things like school-based law enforcement and school hardening and these types of measures that disproportionately harm the most marginalized students, right? So when you think about threat assessments or people coming in to do threat assessments, those are going to harm disabled students and disabled students of color, right? Because they are going to be deemed as threats based on things that are not evidence-based, right? And some of the principles that we talked about is getting this evidence-based data and being able to promote safe and healthy school climate. So from an individual's perspective, how to be an advocate for your child or your student, I can't tell parents how to be the best advocates for their students, right? That's not my place. But I do think it's really important to understand that when the most marginalized students are harmed or are not safe and included in the school environments, that harms all students, right? When school discipline practices like restraint or seclusion are implemented on disabled students or students with intellectual or developmental disabilities, those practices can be extended, right? And that puts all students in danger.
Could you be a little more detailed, AJ, on what that restraint involves, so we can imagine a specific example of it?
So this is AJ again. Restraint can look all kinds of ways. I think I don't want to speak out of turn, but anytime we are physically restraining a child, whether that be with school resource officers or law enforcement, is wrong. I don't really know how to be more explicit than that. I don't know if
would the restraints be imposed because a student is severely disabled in some way, maybe is acting out as a result of a disability? I'm trying to kind of help imagine the circumstances you're trying to prevent.
Okay, so I hope I'm understanding this properly. Restraint can be arbitrary, so it will affect disabled students or students who are viewed as having behavioral problems, quote unquote. I don't really like using that term, but it can also be used on students who are not considered disabled or on an IEP. It can be used as a form of discipline in some schools. We talked about corporal punishment, which isn't necessarily restraint or seclusion, but those types of things, again, if it's affecting the most marginalized communities, oftentimes it's disabled students of color whose behavior has been deemed as threatening or even criminalized. Those can be used in arbitrary ways on other students. So it's not just disabled students that are impacted by these practices. I hope that answered the question.
I'm also happy, Sandy, to speak to that, to build on what you said, AJ. There are times when a young child may be having a temper tantrum at school, because sometimes young children have temper tantrums, and a police officer might put a young child in handcuffs. So a child who is behaving like a child may be put in handcuffs, and we know that that hurts them, that is traumatizing, and that is not helping them to learn. We know there are too many examples of too many children who are behaving the way that children do and feeling big feelings the way that children do, whose needs are not being met, who are reacting, who are communicating, and find themselves gripped up against the wall, or they can find themselves with a big adult sitting on them. And what we are asking is for the federal government to intervene and say, this is the wrong way to treat any child. And the fact that it happens more often for children who are Black, more often for children who are disabled, means that it is only more wrong. And we are asking for appropriate training for teachers so that there are positive responses to children's behaviors, and so that schools are safe and welcoming places for all children to learn and grow. To take on some of the other questions in the chat, and just to uplift Michelle's response, Patrick, saw your question. I think one thing to keep in mind, there's a lot of discussion about the attacks on curriculum, the books that children are allowed to read, the lessons that children are allowed to learn, the aspects of our history that children have the opportunity to wrestle with, as Morgan described. It is impossible to believe that those policies are not translating to how children are being treated in the school. It is unlawful to bully or harass a child on the basis of their race. And when we erase children, when we take children out of the curriculum, when we deny children the opportunity to see themselves reflected, how else is that showing up in the school? I think we are looking forward to greater engagement by the Office for Civil Rights, which is responsible for protecting all students from discrimination on the basis of race, color, national origin, sex, and disability. I think we are looking to greater leadership from the Office for Civil Rights, the Department of Education, and the White House. We are also looking forward to the release of a Title IX rule that would protect all students from discrimination based on sex, including students who experience sexual harassment or students who are LGBTQ, and looking forward to a rule that would ensure that transgender children have the opportunity to participate in the school day, including in athletics programs alongside their cisgender peers. There is a lot more this administration can and should be doing to ensure that all schools are free from discrimination for all children. I'll stop there and see if any of my colleagues would like to respond to any of the other questions in the chat.
At the risk of interrupting any of our speakers, I'm so anxious to hear responses to some of the other questions, Liz. We have a question from Peter Sherman. Can the speakers tell us in a general sense what is happening around student achievement and where the gaps are widening and where the kind of measures that we're talking about today are really aimed at creating or narrowing the achievement gaps? Where have we been successful and where are you most worried about the gaps widening?
I'm happy to start and see if any of my colleagues want to jump in. The recent NAEP NAEP data underscored what I think all of us believed to be common sense, which is children have lost a lot of instructional time during the COVID pandemic, and that for some children, that cost has been even more significant. I think one of the reminders here is that we cannot return to normal of 2019, that we need greater progress on equity and equal opportunity. All of the issues we talked about today contribute to the question of whether or not students have equal opportunity to meet grade level standards, to read and do math on grade level, to be college ready. We've talked about whether children have equitable access to high quality or an early education. We've talked about how children are treated in schools during the school day, whether they're free from the discrimination of exclusionary discipline. We've talked about whether they have access to college and the opportunity to demonstrate their qualifications, their gifts, their talents, and their experiences. And we've talked about whether families will be able to afford the education they sought for themselves before maybe they became parents. But there are a lot of other issues we haven't talked about that are interfering with educational opportunity. Funding in this country is not shared evenly. Schools that enroll a larger share of white children have less money than schools that enroll a larger share of children of color and English learners. Without equal educational opportunity, we are, as a nation, are losing out on tremendous talent, and we have a responsibility to ensure that all schools are free from discrimination and then all children have an equal educational opportunity. We see data point after data point showing us that there is not an equal opportunity for all children. That is why we need policies like affirmative action and like early care and education, why we need positive school discipline, why we need to focus on college access and affordability. All of these pieces come together and influence whether or not students have the opportunity to achieve the education that they are owed. So I'll stop there and see if anybody else wants to speak on the larger question.
Whitney Pessic, I guess I see you are entering something in the chat. Do you want to share? I was thinking of
I'm so sorry, Sandy. Someone flagged that I misspoke and I want to correct what I said. Thank you.
Okay.
It is the case that for schools with white children have more money. Schools with children of color have less money. Schools with lots of poor children have less money. Schools with fewer poor children have more money. So in this country, we do not provide sufficient funding to meet educational need. Thank you for pointing that out and having the opportunity to correct. Sorry, Sandy.
No, that's fine. Whitney, do you want to share what you just entered in the chat? And then Liz, if it's okay, I'm going to go to our traditional final question for each of our speakers, including you. Just a soundbite from each of you would be a wonderful way to end the session. But Whitney, you first.
Sure. I was just quickly going to say on student achievement that there's a lot of attention in the media about, the learning loss during the pandemic. But I think it's also important to point out that poverty plays a huge factor in student achievement. And we made huge success in alleviating a lot of children living in poverty when we had the enhanced child tax credit and we let that expire. And I just think it's important to note that the pandemic was largely, out of our control, but our policy decisions around children living in poverty are within our control. And so if we're really concerned about student achievement and learning loss, we should think about policies like the child tax credit. Thanks, Sandy.
Well, I think that's a terrific note to start the final question. Each of you has highlighted a specific aspect of education policy that you feel most needs to change and why. In our last 3 minutes, could each of you tell us in a very short single sentence what you most hope would happen this year, not the bad news, but the good news, because that is something we can also that will help guide us in watching and reporting what is happening at the local level around that aspiration. So if we were to start with you, Liz, what is the most important policy change or decision from the courts or breakthrough benchmark development that you think would improve the state of education, opportunity, and civil rights for 2023?
It's hard to pick just one. I will say my hope is that the Supreme Court will show up for equal opportunity in the Constitution. We will see affirmative action reaffirmed as it has been with precedent. We will see the allowance of the president's student loan debt cancellation. We will see this Congress commit sufficient funding to ensure access to high quality early care and education and support positive school climate strategies and move away from criminalizing approaches in schools. And most of all, we'll see that every child and family has the opportunity to be treated with respect and dignity by their educators, their school leaders, their school boards, as we recognize, appreciate, and understand that a diverse and inclusive education benefits all children in the nation as a whole.
Well, you've given a very eloquent description of how to improve student climate, not just education policy, and thank you for that. Could we go to our next speaker, who is Genji? What would you most want to see happen? What would your headline be? This year, this is what has to happen.
Well, I'm a lawyer as well, so I would underline that I hope that our courts recognize that the law and the facts and the Constitution is on the side of expanding opportunities for highly talented people of color, both through the affirmative action program and through the debt relief program. I also would like to see us continuing to center the voices and lived experiences of those who are the most impacted by these programs, including communities of color, who I know all of the journalists on this call serve. So thank you for your work.
Thank you. We'll go, AJ, what is at the top of your priority list to see happen this year?
Hi, this is AJ. I won't take a Supreme Court case or a legislative position, but I really hope that we start viewing children as children again instead of threats to be afraid of, and we support and invest in our children in a loving, caring, supportive way, and instead of acting like being a child is, automatically some type of criminal activity. And I know that's a big ask for society to do, but that would be my hope.
That's very well said. Michelle Turnage Young, your top priority for 2023.
That's a hard one. So everything everyone else said, but also, making sure that we're cognizant of whether there are actually equal opportunities for students to get access to the educational experiences that will propel them forward in life.
That's definitely something I would lead off an editorial with. Very well said. Morgan Craven, your best message for us for changes for 2023.
I'm so sorry. I think that you said my name, but I'm having internet issues. Can you hear me?
Yes, definitely.
Okay,
Hear you.
perfect. I guess that I really hope that we can stop what's a really inappropriate politicization of education, because it's interfering with the safe, supportive learning environments that we want, that are fundamental to student success and learning. And we can't have, everything that we want for schools. We can't have excellent schools for all students if we don't build that up intentionally without interference from all of these outside agendas. And I agree with really centering young people and families, particularly those from historically marginalized communities, in that work.
Thank you for that excellent summary. And Whitney Pessic, I guess I'm asking you to repeat what you said as your final message about the earned income child tax credit. But if that, or whatever your best hope or your best, the change you'd most like to see in
in addition to the robust federal investment that Liz mentioned, I also would just say that, I think an increased recognition that the child care system really is not just a support so that people can work, especially women can work, but that it's a dignified, super important profession, and that the educators deserve to be compensated and respected as such, and that it's such an important piece to child development and the future of the United States, and that it's not just a work support, but that it really is important in those other ways as well.
Thank you. Thank you to all six of you, and to the Leadership Conference Education Fund, Maddie Goldman. This has been an amazing opportunity for us to hear from people on the front lines with details and perspectives on what is going to be critical to improving education in 2023. You've really sharpened our lens. We are very grateful, and thank you. We hope we can come back to you in 6 months and revisit where we're at. Thank you very, very much. This conference is now adjourned, and have a great rest of your day.